Ever heard of a court where a duel could legally settle a dispute, or where you could be sued for using someone else's coat of arms? This isn't a fantasy novel. It's a real part of English history called the Court of Chivalry. So, what exactly was this court? Officially known as the High Court of Chivalry, it was a special civil law court with jurisdiction over matters of heraldry and military affairs. Think of it as the legal backbone of the knightly class. It dates back to the reign of King Edward III in the mid-14th century. At that time, England was heavily involved in the 100 Years' War with France, and the army was a mix of feudal levies and paid soldiers. This created a need for a system to manage military discipline, handle disputes between soldiers, and regulate things like ransoms for captured prisoners. The court was presided over by two powerful figures, the Lord High Constable of England and the Earl Marshal. The Constable was the supreme commander of the King's armies, and the Earl Marshal was his second in command, responsible for discipline and organization. Together, they formed a tribunal that could enforce the law of arms, an international code of military conduct understood across Europe. If a knight captured another in battle, the Court of Chivalry would ensure the ransom was fairly set and paid. If two soldiers argued over who had the right to plunder a certain part of a captured town, this court would decide. It was essentially the HR and legal department for the medieval military machine. The case dragged on for 5 years and featured testimony from some of the most famous figures of the age, including the poet Geoffrey Chaucer and the knight Harry Hotspur Percy. Queen Elizabeth I, however, ended up stopping the duel at the last minute, perhaps seeing it as a bit too archaic even for the 16th century. As the age of knights and castles began to fade, so too did the Court of Chivalry's military importance. The standing armies that replaced medieval hosts had their own systems of court-martial. This left the Earl Marshal, a title held by the Duke of Norfolk, in sole charge of the court. Its focus shifted almost entirely to heraldry, but even that role dwindled. The court became seen as an aristocratic relic. For nearly 200 years, from 1737 onwards, the Court of Chivalry didn't sit at all. It was dormant, a sleeping giant of legal history. Many people assumed it was gone for good, a curious footnote in the law books.